Dear students, welcome again. There was some technical issue. We'll continue our discussion. I was explaining like a brief about me. I was telling brief about me. My dear students, I've been teaching UPSC aspirants for the past 12 years. And in this regard, I would like to tell one point, and I always say that is for all my success, what I have with respect to writing books or teaching, or and also with respect to my little success in civil service examination, all to a greater extent goes to M. Lakshmikant, the stalwart of the polity book, a very simple, very humble, very kind, very helping person. Is the person who made me realize that I also can write, and also he gave me some guidelines as to how to teach, what are the main requirements. So these were the reasons. And as I told you, my dear students, I have topped 2015 ethics paper. That is the reason I took up writing ethics books. And since students requested that, sir, nobody is doing India year book, please take up these things. I have paused the things for a while and I have taken India year book. After which I'll be taking up like ethics or other things according to the needs of the students. My dear students, all the material I'll be giving on the Telegram link, and also you can contact me at this Unacademy link. My dear students, here at Unacademy, we are comprehensively covering the syllabus. And as I told you, we have got two kinds of subscription, that is Plus and Iconic. In both the cases, please take my promo code, that is Buddha10, and you will get 10% discount, my dear students. We are coming up with many new batches on the 18th of February, and also, my dear students, we are giving choice to you. We are coming up with bilingual. If you want two languages, Hindi and English, you can go for that. We are giving Hindi only, we are giving English only. We have got 6 months, we have got 1 year, we have got 2 years, and also NCRT batches are going on, my dear students. That too, again, English and also Hindi. What are you waiting for? Take a course. The ball is in your court, my dear students. After the request of the students, like many were thinking of taking both optional and the GS. So we have come up with a combo pack where you'll be getting nearly 40% discount if you go for 3 year subscription, my dear students. Having said that, let us begin our discussion and continue further with law and justice chapter. My dear students, this book is yet to release, but nothing to worry because I'll be going to the source. I'll be going to the source material from which India Yearbook has been prepared, and also I'll be more authenticated than your India Yearbook because India Yearbook will be updated maximum like September 2020. In many cases, if at all, in some areas, December 2020. But what I teach will be up to date to the date I have updated the things. So I have come up with two ways. One is completely covering the India Yearbook A to Z line by line to begin with the first. Afterwards, I'll be covering the things in a very shorter version. This first one, like A to Z, line by line, will be useful for those who have not yet read the yearbook and also who are preparing for 2022, 23, all those things. And those who have already read the India yearbook, I request them, like, it is better if they read on their own because it will be very easy for them and it will take very less time. No, if they think that they want to listen to my class, they can go for the part 2 where I will be brushing off the whole India yearbook in like 25 to 30 hours, the entire thing. My dear students, having said that, these are the topics which we have covered. Today we will take up judiciary. Before that, in 10 to 15 minutes, I will glance you through the important things which we have covered. My dear students, police is a state subject. It is The police, which is assigned with the maintenance of public order and prevention and detection of the crimes. In the big cities, you'll be having commissioner of police who will be enjoying the magisterial power. All the senior positions in the state are manned by IPS. Very important because many won't be knowing this. This is one of the very important aspect in police. Police is a state subject, but they are manned by your IPS who is recruited and appointed by the center. Then your Indo-Tibetan border police. It is a very important and strategic force which is guarding our Indo-China border. And my dear students, they cover from the Karakoram Pass in Ladakh to Jachapla in Arunachal Pradesh. BSF, a very important, they will be guarding your Pakistan and also your Bangladesh. And the headquarters is in New Delhi. Next, the Assam. They are called Sentinelians of Northeast and also Friends of Hill People. The headquarters is still Shillong. This question, like Sentinelists of Northeast, already asked once. Headquarters is in Shillong, very important. And Assam Rifles is one of the oldest, a very important thing. It was raised in 1835 as Katchan Levy, and it is one of the oldest paramilitary force, and it has played a great role in the assimilation of North India with the Indian mainstream, my dear students. Then National Security Guard, here it is a federal contingent force. Both army and the central armed forces are present there. The motto is Sarvatra, Sarvattam and Suraksha, means omnipresent, omnipotent and defense. It is mainly based on the contingent forces, federal contingent forces of UK and Germany. My dear students, next is Central Reserve Police. Here it is a multi-dimensional force. Like it is covered in almost all the sectors, almost all the areas. It is the only paramilitary force having three Mahila battalions. My dear students, paramilitary forces, not the army. They are the auxiliary to the army, right? Then 21st October is celebrated as Police Commemoration Day. April 9th as Valor Day, the Great Bravery Day. And your CRPF is also involved in international deployments. Rapid Action Force, a very important thing. This is mainly for communal violence and situations like that. And these rapid action forces, they are the only armed forces which act as like undetached or which are not together. They are organized on an unattached pattern. Means each battalion is independent on their own and they are stationed in communally sensitive areas. Next is your Cobra. It is to fight against the Maoists. And your central industrial force, which was primarily before liberalization we had got public sector undertakings. For that it was limited, but after liberalization it has got a huge task of maintaining and providing security to, I repeat, crucial infrastructure installation. All infrastructure installations are coming under the central industrial security force. And it is also the largest fire protection service provider of the country. Sashastra Seema Bal, it was previously known as Special Service Bureau. Recently, like that is in 2021, 2001, it has been given the security, the border security of Nepal. In 2001, in 2004, it has been given the Bhutan charge also. My dear students, civil defense, very important concept. Civil defense means here it includes any measure not amounting to actual combat. This slide is very important. It holistically explains everything about civil defense. The main thing with respect to this is it is not actually amounting to the combat, but it affords protection. This Though it is been like Civil Defense Corps and Civil Defense Act is though applicable to all areas, it is active only among the border districts. My dear students, in 2011, we have enlarged the definition of civil defense to include even the disaster management. As I told you, it is applicable to throughout the country, but it is raised in such areas where we consider them to be tactically and strategically very, very vulnerable. My dear students, it is primarily organized on a voluntary basis, and the role is shifting from the previously conventional weapons to the latest like nuclear, biological, chemical warfare. So civil defense concept is changing, evolving over a period of time. My dear students, home guard here it is a voluntary force as the civil defense. Here, my dear students, it is the responsibility of every citizen to take care of the nation. In this regard, we have come up with a voluntary force, and home guards act as auxiliary to your police. Your paramilitary forces act as auxiliary to army, and it includes providing civil defense duties also. And all states have home guards except your Kerala. Home guards are two types. In a broader way, they are rural and urban. In border state, you also have got border wings of home guard battalions. The acts are done and enacted by the Ministry of Home Affairs. Along with that, we have got some of the rules made by the state and union territory also. Everyone in the age of 18 to 15 years is eligible for home guards, and normal tenure is 2 to 5 years. And the expense is shared between the center and the state. Fire service, a very important thing. The gist what you have to understand is like your law and order, like your police, for your fire service is also a state subject. And another one important aspect still in that is fire service is being included in the municipal functions in the 12th schedule of the Constitution of India in terms of Article 243W, and it is the responsibility of the state to enforce national building code. It is not the central responsibility. And 13th Financial Commission has recommended the need to restructure the fire and emergency services, and also asked all the municipalities having the population more than 1 million according to 2001 census to have a fire hazard response mitigation plan. Ministry of Law and Justice, this is one of the oldest, not one of the, it is the oldest limb of government of India. In prelims, this may be asked, and it dates back to 1833 when the Charter Act of 1833 was enacted by the British Parliament. See, my dear students, here once again, I give you stress upon the things. Anything you come across like act, law, statute, you please understand that these are the things done by your legislature, your parliament. Anything ending with rules, regulations, bylaws, they are done by your executive. So these rules, regulations, all these are formed by your executive because your legislature gives permission. So this is known as your subordinate legislation. This is known as subordinate legislation. And also it is known as delegated legislation. Is it clear? Your executive will be making rules, regulations within the framework of the law, statute, or an act. This power is given to your executive by your legislature. Is this clear? Any doubt with respect to these things? Next, the exercise of legislative power has evolved over a period of time. First, it was in the Charter Act of 1833 when the Governor General in Council was given the power. I repeat, this law making power, the legislative power, was given for the first time by 1883 Charter Act. It was given to Governor General in Council. Along with that, your Indian Council Act of 1861 further added, and these two principles were the things behind the legislation which all the Governor General in Council carried out till 1920. I repeat, from 1834 to 1920, your Governor General in Council was legislating the things. This power was given by Charter Act of 1833 and also your 1861 Act. After that, from 1921, Indian legislature was making the laws. The legislative power was with Indian legislature by virtue of your 1919 Act, in Government of India Act of 1919. And between 1947 to 1949, that is before we the constitution came into force in a full swing, that is till 26 January 1950, India was a dominion. Here the laws were made under Government of India Act of 1935, and after January 26, 1950, the parliament is making the laws. Is this clear? See how, who are the people who are involved in lawmaking? Just have some of one of the first beginning is with Charter Act of 1933. That is the beginning of the law ministry. That is the beginning of one of the ministries, oldest ministry. Their Governor General in Council was discharging those duties till 1920. From 1921, Indian legislature, when India was a dominion. Dominion means after independence, Indian Independence Act was passed. That is 15 August 1947 till 26 January 1950. We were dominions. In during that period, the legislation was carried by the Dominion legislature according to Government of India Act of 1935. After that, the constitution came into being and the parliament is taking care of the things. Very, very important slide, my dear students. Then, as we have explained, the departments which are there in the Ministry of Law and Justice are Department of Legal Affairs. It is dealing with the interpretation of the constitution and laws and legal services. Next department is legislative department. Legislative department is with respect to drawing the principal legislation of the central government. The Department of Justice is concerned with the appointment, resignation, removal of the Chief Justice of India, judges, all these things. Then four important components of Indian legal system, very, very important. This may be asked, my dear students, please bear these things in mind. These are not given in any book. Indian legal system has four important components. They are the basic values and principles enshrined in the constitution. And the second one is rights and obligations confirmed by the ordinary statute. Ordinary statutes means ordinary laws, laid by the legislature. Then the organization set up for enforcement of these rights and obligations, and also the legal and the judicial person, the judiciary. So very important, I repeat again, components of our Indian legal judicial system. Legal system is one is with respect to the values and principles which are enshrined in the constitution. Then the rights and obligation confirmed by the ordinary statute. Then again with respect to the organization set up to enforce these rights and obligation. The third, last but not the least, legal and judicial personnel. My dear students, in all these things, one of the main binding force is account chain of accountability towards sovereign, a very, very important concept. Chain of accountability towards sovereign. Who is sovereign here in India? If there is anyone, then it is invariably people who are sovereign. Whatever may be the thing, at the last they are accountable to the people. Chain of accountability. Say for your IAS officer is accountable to a minister. This minister is accountable to the legislature, the parliament. The legislature is accountable to the people. So there is a chain of accountability towards the sovereign. Towards the sovereign in democracy, my dear students, sovereign is only and always people. Source of law, once again, very important. There are four important sources of law. They are our constitution, our statutes, means the laws made by the legislature, our customary laws, and the case laws. Here, my dear students, why rules, regulations, and bylaws, they are not the source of law? I repeat, see, the sources of law are only four. They are your constitution, your statutes, that is legislation, customary law also we are adding, but not the rules and regulations. Because, my dear students, rules and regulations are made under delegated legislation. Delegated legislation means who is delegating the things? Your legislature is delegating this authority. What is the meaning of delegation? Delegation means the ultimate authority and ultimate responsibility rests with the legislature itself. Delegated legislation is not decentralization. In decentralization, both authority and responsibility are transferred to that point. Is it clear? So, what are the sources of law? If they say that rules and regulations, then they are not the sources of law. Sources of law are constitution, your statute, customary laws which are not in contradiction, which are not in conflict with the constitution or the statutes, and the case laws. Case laws means the wordings, the judgments given by higher courts. What are these higher courts? Higher courts consists of two, that is your Supreme Court and High Court, right? Case laws are very very important, my dear students. And enforcement of law, here this is one point which you have to internalize. I've kept this slide only because many students are confusing in this aspect. My dear students, as you are aware, with respect to center, you have got central list where central will be making laws. With respect to state, we will be having state lists where state will be making. But in case of concurrent list, case of concurrent list, both parliament and the state legislature can make and will be making laws. But in the event of repergency, in the event of difference, in the event of coming conflict, the laws made by the parliament shall prevail over the law made by the state legislature. This is well and good. Many students understand this. Next, the laws made by the parliament shall prevail over the law made by the state legislature with respect to concurrent lists to the extent of repergency only. Say, for example, state law. Say, think that this is the state law, and this portion of the state law is repergency. So only this law, this portion will be void, not everything. And also, this portion won't be void if the later law has been reserved for the consideration of the president. See, there is some differences, there is some opposition. If this portion is reserved for the consideration of president and has received his assent, in that event it shall prevail. Is it clear, my dear students? Moving forward, the judiciary. Till now, my dear students, the things what we have discussed are very important. Further down, we will be discussing some of the things which you already know, but there are many things which are not given in any book. It is going on only in yearbook. Though my teacher Lakshmikant has somehow put most of the things, some of the things he has not put in India yearbook. There are many many new things which still are not given, not taken up by the Lakshmikant book. So in this respect, we'll see some of those things. Supreme Court, a very very important thing. This is the Supreme Court emblem. My dear students, here please internalize. Supreme Court was established in 1st October 1937. Means it is based on your Government of India Act of 1935 when the act came into being, because 1935 act gave for federal structure. So because of this federal structure, Supreme Court, then it was called Federal Court, came into being. You can remember the date also because one day before Gandhi Jayanti, 1937. But the present Supreme Court came into being in 28th, on 28th of January. That is 2 days after Republic Day. Here the thing, yato yato dharma ratato jayam means wherever, like very difficult for me to read Hindi. Wherever the meaning, I will sum up the thing. The meaning is where there is truth, there is victory. Where there is truth, there is victory, is the meaning. My dear students, at the apex of the entire judicial system exists the Supreme Court of India with high courts for each state or group of states. Here, two important things. One of the thing is here we at the apex, what we are having at the apex of the entire judicial system exists Supreme Court of India. Supreme Court of India with a high court for each or a group of states. See here, one of the important thing, they are talking about not only the Supreme Court, they are talking about the High Court also. The Supreme Court and High Court are called as the apex courts. I repeat, it is not only the Supreme Court. Supreme Court is definitely higher in hierarchy than the High Court. But when we speak about High Court, when we speak about higher judiciary, it is always Supreme Court and High Court. See, it will be, and one, this is one point. Another is High Court for each state or group of states. There are three high courts which have jurisdiction over more than one state. So, is this clear? There are three high courts which have jurisdiction more than one state. Under high courts, there is a hierarchy of subordinate courts, very, very important. So, here, this is your Supreme Court. Below Supreme Court, you have got high courts. Below High Court, you have got hierarchy of subordinate courts. So when they say that subordinate courts, all the courts which are below your High Court, which are in the state. Is this clear? So High Court is not called subordinate court. So I am stressing the things. High Court is not subordinate court. It is a superior court. It is an apex court. High Court is working below the Supreme Court, but it is not a subordinate court. Right? Next, districts and session judge. This is one of the most important concept because many of the students they do have some idea of what is Supreme Court and High Court, but when it comes to the subordinate courts, they are not having that idea. My dear students, Supreme Court, then you have got High Court. Below this, you have got hierarchy of subordinate courts. In that, the first in the hierarchy is the district and session judge court. I repeat, district and session judge court. Here, he is the highest judicial officer. Very important. He is the highest judicial officer in the district. He is known as district and sessions judge. Here, very important point. District and session judge are same. When he takes up the cases with respect to civil laws, when he takes up the cases with respect to civil laws, he is known as district judge. When he takes up the cases with respect to criminal law, he is known as sessions judge. Is this point clear? Below him, there is once again hierarchy with respect to civil justice and also with respect to criminal justice. Is this concept clear? To make the things clear, let me just take a new sheet for you. Right. The Supreme Court. Here Below Supreme Court, there are 25 high courts. 25 high courts. These are the high courts. Three high courts have jurisdiction more than one state. Right? Below this high court, you have got district and sessions judge. Districts and session judge. Below him you have got two more hierarchies. One with respect to your criminal justice and another with respect to your civil justice. This is the whole structure. District and session judge means the same person. Districts and session judge court they call. Here, some days he takes up civil matters, then he is called as district judge. Some days he takes up criminal matters, then he is called as session judge. So, the court is in general known as districts and session judge court, right? This is about these things. This is a very important and most misunderstood concept. My dear students, as I told you, at the apex of the entire judicial system exists Supreme Court. At the apex, you have got Supreme Court, and also along with that, you have got High Court for each state or group of states. Under the High Court, there is a hierarchy of subordinate courts. This you all know. But my dear students, here Supreme Court, High Court, and also subordinate courts. Along with those things, you also have Panchayat courts. Panchayat courts also function in some states, and they have got many names, various names like Nyaya Panchayat, Panchayat Adalat, and Grama Kacheri. What for? These decide civil and criminal disputes. Very, very important, my dear students. They not only decide civil cases, they decide both civil and criminal disputes of petty local nature. Is it clear? So they are not taking very big things, they are taking petty things. So civil and criminal disputes of petty local nature, and different state laws provide jurisdiction for these courts. Very, very important, my dear students. This is entirely different here. Here, when you come to panchayat codes, these are the codes which are created and based on the state laws. Clear? And these also are engaged in petty local nature of things. They dispose of both civil and criminal disputes. Clear? Any doubt with respect to these things? Panchayat codes, a very, very important thing, my dear students. Next, moving forward. Here, king in council or privy council, a very, very important concept. Here also, this is one of the original thing which is not given in any book. Privy council is one of the top court. To give a a analogy for you to make understand is the present status what we have for Supreme Court. This was the status of your privy council before the federal court or the Supreme Court came into being. I repeat, so it was the highest court. It was also called king in council, and all these appeals used to go for the privy council. My dear students, this privy council was of very, very immense help to the Indian people, especially with respect to the legal system. Respect to legal system. Because of this privy council, the British law which we have now, the law through which, sorry, the judicial system what we have entirely inherited from the Britishers. The laws we have, the penal codes what we have, to a greater extent, are taken from the British law system is prevailing even today, and the Privy Council during its vast 200 years has given more than 2,500 decisions. these decisions still act as a very, very like gems of reference, because our law still depends on the British legal system to a greater extent. So if there is any doubt, even now, even our apex court refers to these judgments which were given by the privy council. My dear students, let me elaborate these things in a systematic way. Please concentrate. This is a very, very important thing. During the British regime, King in Council or the Privy Council, as it was generally called, was the highest forum to entertain appeals. During the British rule, which is the highest form for appeals, it was your Privy Council. It is also known by the other name, King in Council. It was the highest form to entertain the appeals from the judgments and orders passed by the court in India. Right? Any court, if it passes any judgment or order, at the last end for appeal was your Privy Council. On enactment of Judicial Committee Act of 1833, on enactment of Judicial Committee Act of 1933, it came to be called as Judicial Committee of Privy Council. Privy Council's orders were, Privy Council's decisions were in the form of advisory, but it was always followed. The decisions of the judicial committee, the decisions of the judicial committee of Privy Council used to be couched, means phrased in the advisory form. They were used to be in advisory forms. Though in practice the crown always accepted its advice, and it was unthinkable that its report will not be given effect. Means almost, though it was not binding, no, it was not binding, it was almost equal to binding, because it was unthinkable, unimaginable that the crown will not accept. My dear students, this was very, very important thing. Private, the Privy Council acted as a channel through which the English concepts came to be assimilated in the Indian laws. What was the channel? It was the Privy Council. Privy Council was the channel through which the English concept was accumulated in Indian laws. The laws what we have, the laws through which we are bound, are passed on through the Privy Council from the Britain, from the England. It served as a bridge between the Indian and the English legal system. Privy Council was the bridge between English legal system and the Indian legal system. My dear students, this is very, very important. The legal system what we have to a greater extent owes many things to English legal system, over which the legal ideas traveled from England to India. It was through this body that the common law of England was introduced in India under the British regime as the basis of its legal system. So, by now, you know the exact importance of the private council. It plays a very, very great important role. It only through this was only the facilitator through which we assimilated the things of the British legal system. It served as a bridge between India and the English with respect to the legal system. It was through this private council that the common law of England was introduced in India under the British regime as the basis of its legal system. Not only that, my dear students, during its career as the highest court of appeal, during its career has the highest court of appeal, that is Privy Council for India, over a period of 200 years. Privy Council rendered over 2500 judgments. Privy Council has given over 2500 judgment. This is given, the exact text is given by Supreme Court website itself. They say that till today these judgments constitute the foundational source for law on many points in India. See the importance, my dear students. On the Supreme Court website, they have mentioned this. Though this has been like reproduced in your India book, on the Supreme Court website, they have given this information, what I am reading now. The Privy Council's decisions, the judgments till today, these are these constitute the foundational source of law in many points in India, even till today, my dear students. And this was the last resort with respect to appeal all these things. But there was a growing demand, and also was a growing discontent among the Indians for the establishment of Supreme Court in India, for the establishment of a federal court in India. Why? Because the appeal to Privy Council was very costly and beyond the means of the common man. Common man cannot go to England. It was very costly for them to appoint a lawyer, make him go, take his case in England. It was very difficult. And more than that, one of the thing is like it detracted from the self-respect of Indian people. My dear students, see, we have done something. There is some litigation, but this litigation was decided by the Privy Council in England. So this distracted the self-respect of Indian people because it was Indians. It was what we are involved. The laws, everything under which we should be ruled is Indian only. In some sense, we are giving the superiority to the British because the Britishers were deciding. Last ultimate appeal was in Privy Council. So it's distracted the self-respect of Indian people. We are going for British people for the last appeal. So because of this, there was a huge demand for the establishment of Supreme Court in India. Government of India Act of 1937 introduced a federal constitution to India involving distribution of powers between the center and the constituent units. In this regard, like as it is given in the Supreme Court website itself, Federal Court of India began functioning from October 1st, 1937, a very landmark day in the Indian history. So October 2nd, our Mahatma Gandhi Jayanti, one day before is your October 1st, that is the day on which the Federal Court began working, Federal Court of India, October 1. Excuse me. And next, to begin with, the federal court has a very limited jurisdiction, confined to original jurisdiction in disputes between the center and the constituent. So, the federal court, which began in 1st October 1937, to beginning, it had a very limited jurisdiction. What was that? It was conformed to the original jurisdiction. Original jurisdiction means that goes to only the federal court, no other court directly. If there is any dispute between the center and the constituent units, see here they are very carefully using the term, they are not using center and state. Then the state concept was still not there. Constituents, there were some princely states, there are some areas which were under the control of commissioner, many things like that. So any dispute between the center and the constituent units, it was the original jurisdiction of the federal court. And inter se among the later means any quarrel, any dispute between the constituent units themselves. And advisory jurisdiction and appellate jurisdiction on a certificate from the High Court. So, if the High Courts agree, if the High Courts give a certificate, then there was advisory jurisdiction and also appellate jurisdiction, which was going to your federal court. So, what was the gist? Gist was that original jurisdiction, if there is any conflict between your center and the constituent units, it used to go for your federal court. And also, when it is certified by the High Court, it used to have appeal and also advisory jurisdiction. Not only that, appeals from the federal court would go to your privy council from the judgments rendered in exercise of the original jurisdiction or by leave of the federal court or the privy council. So here from high court, some cases were going to your federal court, and also appeals from the federal court could go to privy council from the judgments rendered in the exercise of Original jurisdiction. What was the original jurisdiction? It was dispute between the center and the constituent units, or the constituent units also, or by leave of federal court or privy council. Here the term leave is important. My dear students, we often use the leave of Supreme Court. Leave means what? Like say for example, you are taking a leave. What does this mean? You are taking permission. So it means special permission. So a case can, on the special leave of Supreme Court means Supreme Court is giving permission to take the case, right? So leave of federal court means it is a special permission of the federal court or the private council. In cases involving interpretation of the constitution, the parties had to first go to the federal court in appeal from the high court. Is it clear? So, in cases of interpretation of the Constitution, interpretation of British Constitution, British Acts, British laws, the parties has to go to first federal court in appeal from the High Court. And in other cases, appeals from the High Court led directly to private counsel. This was one of the unique feature. Only in case of constitutional matters, they have to go to the federal court. In other cases, appeals from the High Court lie directly to your private counsel. Thi- This could give advice on such questions of public importance as were referred to it by Governor General in his discretion. The same, the advisory jurisdiction what we have with respect to Supreme Court, the same it had with respect to the federal court. These are the things I am talking about the federal court. Is it clear? Then, the appellate jurisdiction of federal court was enlarged by the enactment of Act 1 of 1948, and appeals were provided to federal courts from the judgment of High Court in some circumstances in which appeals could be brought to private counsel without any special leave, and also by special leave of the federal court in any other case. My dear students, by the Act of 1848, sorry, by the Act of 1948, the appellate jurisdiction of a federal court was enlarged. How? The provided appeals were provided to federal court from the judgment of the High Court in the same manner as the previously. It has to go for your private counsel. Repeat, appeals were provided to federal court from the judgments of the High Court in the same circumstances in which appeals could be brought to private counsel without any special leave, and also by special leave of the federal court in any other case. But however, appeals to private counsel was still possible by leave of the federal court or the private counsel. So appeal to private counsel was still possible. How? By the leave of federal court or the council itself, private council itself. From 1949, a very important thing happened. See here, even after independence, private council was working. From 1949, appeals to the private councils were abolished altogether, and entire appellate jurisdiction was vested in federal court. This is a very important thing. Is it clear? So even after independence, the appeals were going to the privy council. From 1949, appeals to the privy council were abolished altogether, and the entire appellate jurisdiction was vested in your federal court. Is it clear? Any doubt with respect to these things? If you have any doubt, please let me know. Federal Court of India. When did it establish? My dear students, to be specific, January 28, 1950. On January 26, 1950, Federal Court gave way to Supreme Court of India under the new constitution. After its inauguration in January 28, 1950, the Apex Court commenced its sittings in a part of Parliamentary House. Previously, it was not having building. So after that, it started functioning in Apex Court commenced its sitting in a part of Parliamentary House. The court moved to the present building only in 1958. The Supreme Court of India is located in Tilak Marg, New Delhi. So, my dear students, any doubt with respect to these things? This is like how our federal court became our Supreme Court. My dear students, with respect to Supreme Court, there are very important things which I have to internalize. They are with respect to the court moving to the present building in 1958. It's not that important for general idea, but what is most important is the original constitution of 1950 envisaged Supreme Court with Chief Justice, one Chief Justice, and seven puisne judges. Means those judges other than sorry, other than your Chief Justice. At present, what we have is 33. So, your original constitution provided for only 7, but now we have got 33. Means here Chief Justice and 7. Now here one Chief Justice plus 33 as of now. This is latest, and still India Year book is mentioning these things. This is wrong one, this is the correct one. At present, we have total sanction strength, very important, please internalize. Total sanction strength is 1 plus 33. But as of now, today morning I checked where the present strength is 1 CJI plus 29 puisne judges. Means total we have got 30. I repeat, the sanction strength is 1 plus 33 according to the latest amendment made in 2019, but the present is 1 plus 29 itself as on today when I checked. And one another one important thing is earlier all the judges of Supreme Court used to sit together and hear the cases. All the seven, 1 plus 7. In earlier days, all the judges of Supreme Court sat together to hear the cases presented before them. As the number of judges has increased, they sit in smaller benches of 2 and 3, coming together in larger benches of 5 or more only when required to do so or to settle a difference of opinion or controversy. My dear students, this is a very important aspect. In the number of judges the number of judges is one of the important factor to be considered. Say for example, there is one judgment where it is given by 5-member judge, and if there is any constitutional matter, then that has to be taken care by 5 Supreme Court judges. I repeat, constitutional matter, if there is any case involving constitutional matters, it is given in the constitution that minimum 5 judges should be hearing the case. Not only that, when the president asks for advice, there also 5 judges have to hear this one. And number is of a great significance. Say for example, if there is a judgment given by 7 judges, this can be overruled by 9 judges bench. Is it clear? So 9 judges, it can be overcome only by 11 members, like that. As the number of judges sitting increases, the authenticity, the authority of that bench increases. Clear? Then Supreme Court of India comprises the Chief Justice and other judges appointed by the President. A very important thing is here that one of the most important thing and often confused is with respect to retirement age, that is your 65 years. Supreme Court judges retired upon attaining 65 years. They are appointed by your president. Not only Supreme Court, even High Court judges. This is one more often confused. High Court judges are appointed by your president, not your governor. High Court judges are also having many wide variety, and also in many cases they are equivalent to Supreme Court judges in their service matters, all these things. So, my dear students, one point what you have to remember is your High Court and Supreme Court judges are appointed by your president, but the High Court judges retired at the age of 62. Supreme Court judges retired at the age of 65. In order to be appointed as a judge of Supreme Court, a person must be citizen of India and at least he must have been for at least 5 years a judge of High Court. So he has to be a judge of High Court, one or two or more courts in succession, or an advocate of High Court, or two or more courts in succession for a period of 10 years. See, in other cases with respect to the qualification for judge, High Court, other things, these are not present. High Court judge for 5 years and advocate 10 years, where not in any other court, only in High Court. And very important thing is, very peculiar thing, other than this, a person whom the president considered as a distinguished jurist can also become the judge of Supreme Court. A distinguished jurist in the opinion of president can also become the Supreme Court judge. A very, very powerful place, my dear students. Provisions existed in the constitution. As of now, we have got a provision with respect to two important things which you have to internalize. What are these provisions? They are a judge of High Court. Judge of High Court can act as ad hoc judge of Supreme Court. So we can appoint a judge of High Court who is duly qualified. I repeat, a judge of High Court who is duly qualified to become a judge of Supreme Court. We can appoint him as a ad hoc judge, not permanent judge. Ad hoc means temporary basis. At this end also, we have got retired judges of Supreme Court and also High Court. We can appoint even the retired judges of Supreme Court and also High Court who are duly qualified to sit and act as judges of Supreme Court. Is this clear? Any doubt with respect to these things what we have thought? Moving forward, the Constitution seeks to ensure the independence of Supreme Court in various ways. My dear students, here one of the most important thing is with respect to removal. Judge of Supreme Court or High Court, it is very, very difficult to remove. See the procedure here. Judge of Supreme Court cannot be removed from office except, what are the only condition to remove from the office? Except on the ground of proved misbehavior and incapacity. See here, if a judge is not incapable, if a judge is not involved in misconduct, he cannot be removed at all. I report, he can be removed on the ground of proved misbehavior and incapacity. Proved is also important. If your misbehavior and incapacity is proved, then afterwards they can think of removing. First is they have to prove your misbehavior and incapacity, and all this thing has to happen by an order of the president, except by an order of the president passed after an address in each house of the parliament, supported by a majority of the total membership of that house and the majority of not less than two-thirds of the members present and voting. So here two conditions has to be satisfied simultaneously. Address After an address in each house of the parliament, supported by majority of the total membership of the house, One is majority means more than 50% of the total strength. Say for example, if you have 100 members, then it has to be accepted by more than 50%. That is minimum 51% people have to accept. And by majority of not less than two-thirds of the members present and voting. This is a very, very important thing. So these two conditions have to satisfy. I'll give an instance for you. Say for example, first one, think that there are 100 members. First condition is majority of the total membership. Membership is 100. Majority of the total membership means they have to be like more than 50. That is minimum 51. This also has to be satisfied. And not less than two-thirds of present and voting. Why is this made? Say for example, here say there are only think that there are only 30 members. If you say that only two-thirds of the members are present and voting, then 20 members is enough. Are you getting me? Two-thirds of the present and voting, if there are only 30%, then only 20. To overcome that, we have got two options also. That is total membership of the house, and also two-thirds of the members present and voting is also important, my dear students. Moving further, here another important aspect I forgot, sorry for that. My dear students, present and voting, and they have to be presented to the president in the same session, not in the next session. Say for example, winter session, budget session, in that session itself, not in the next session. They have to be presented to the president in the same session for the removal on the grounds of proved misbehavior and incapacity. These are the only two reasons. On no other reason you can remove. See the difficulties. First is you have to prove the misbehavior and or incapacity. Afterwards, each house, not a single house, both your Lok Sabha and also Rajya Sabha, each house has to pass. The condition is also very, very difficult. That is majority of the total membership of that house, and also by majority of not less than two-thirds of the members present and voting. And next important is that should be presented in the same session, not that all the things happen now and after 1 year it will be presented to the president. Moving forward, a person who has been a judge of Supreme Court is barred from practicing in any court of law or before any other authority in India. This is very, very important, my dear students. See here, why this one? This is to ensure the independence. A person who has been judge of Supreme Court is debarred from practicing in any court of law or before any other authority in India. Why this has been made? This has been made to see that the Supreme Court work independently. How is this possible? Because say for example, if they are allowed to work below any authority, there may be chances of quid pro quo, or there may be chances of give and take. There may be chances of persons compromising their integrity. So we are not giving chance to that at all. Next, the proceedings of Supreme Court are conducted only in English. This is a very, very important thing. Many think that they can be done in Hindi. No, the proceedings of Supreme Court are conducted in English only. Supreme Court rules 2013, the latest one, have been framed under Article 145 of the Constitution to regulate the practices and procedures of the Supreme Court. So, the practices and the procedures of the Supreme Court are made under Article 45. In this regard, Supreme Court itself has made the rules under Article 145. What is that? What is that 145? According to this, like exact article I have put in front of you, subjected to the provisions of any law made by the Parliament, the Supreme Court may from time to time, with the approval of the President, may make rules for regulating the regulating generally the practice and procedure of the court. So it says that Supreme Court can make rules, but what are the things? Subjected to the provisions of any law made by the parliament. See here how there are checks and balances. Subjected to the provisions of any law means if there are laws made by the parliament, it is subjected to those things, these laws. Supreme Court may from time to time, with the approval of the president, see here how the checks and balances are working. Supreme Court is making rules for the regulating the practices and procedures of the Supreme Court. But here the legislature is also involved. This one is very important when you are writing, when you write the checks and balances concept. Parliament is required, and also your president, the executive permission is also required, executive. So these three are working together, acting as a checks and balance. Next, this is a very important thing with respect to some group C and D kind of thing. In UPSC, their chances of asking are very less. As of now, Justice Sharad Arvind Bobde is the present Chief Justice. My dear students, he will be retiring in another 60 or 60, 70 days, my dear students. So, who will be the next? Your Ramana will be the next. Ramana will be the next Chief Justice. So, Honorable Chief Justice Ramana will be the next Chief Justice and he will be the 48th. Based on that, based on the website things, I have made out that next 49th Chief Justice will be your Uday Umesh Lalit. Another person is there, but is not that senior. You will be retiring very early. Next, your 50th of century will be your Chandrachord. So these are yet to come. Until I have given the CJI Supreme Court judges till 2023. I have given you till the 50th, but the present is this one. Till this date, our Arvind will be the CJI of India. My dear students, if you have any doubt, please let me know. Okay, if you don't have any doubt, my dear students, let me conclude the session here. Before that, let me give you some very, very important information with respect to the things which are going on. See here, we have started and we have finished the things with respect to the things which are there in red. We are in judiciary, we'll be covering all these things. And before that, I'll make sure and I will tell you that we will be covering the things in a very, very systematic way, slow and steady, not a problem for you. But when I take up the things with respect to the important points, then I'll go very fast and I'll cover the whole thing in 25 to 30 hours, my dear students. So, what I suggest is with respect to the things, my dear students, the present class is for those who have not yet read India Yearbook and also for those who are appearing in 20, 21, 22, and 23. Those who have already read India Yearbook, I suggest you to go and read on your own or wait for my abridged or short form or important things only, because in this session, in this series, I'll be covering line by line, my dear students, so it may take little time. My dear students, as you are aware, we are into Unacademy Summit 2, a very, very important event happening where there will be over a period of 2 days, there will be 70 iconic speakers and there will be senior bureaucrat, politicians, all. Not only that, many of my colleagues like Siddharth Arora are also speaking to you. They are one of the most renowned faculties and there will be talks and also hands-on workshops will be there. My dear students, all these things are free. What are you waiting for? Please get registered. And my dear students, please don't forget to attend the Unacademy Combat, which is happening, which is one of the most gamified thing which has ever happened. This is a very, very simple procedure. And my dear students, you have got very, very tempting offers. If you are thinking of joining an academy, If you really practice and if you take the patience and if you really plan for the examination, read for it, you can get the things for free. First three we are giving complimentary, first, second and third. For that, if you want to like 6 months, 12 months or 24 months, we are giving for free, my dear students. If you are in first three ranks, for 4 to 10 we have got 75% discount. For 11 to 50 we have got 55% discount. For 51 to 500 we have got 25%. My dear students, what are you waiting for? Compete in that and get the scholarship. My dear student, please don't forget to like, share, and subscribe the thing. Since I'm not feeling well today, I'll be winding up the session little early. I'll get back to you and I'll finish the things present. Let's crack UPSC and let's get first rank. Happy reading.